Good morning, everyone. Our first case is Schooldev East. This is the town of Wake Forest, and we will hear from the appellant.
May it please the court. My name is Toby Coleman with the Smith Anderson Law Firm. I'm here representing the appellant, Schooldev East. With me at the table today is my colleague, Amy Kraut. In the audience are my co-counsel, Dan Gibson and Paul Stam, and also here on behalf of Schooldev East is Jim Way. I'd like to reserve 5 minutes for rebuttal. This is a case about an error made by the Court of Appeals that undermines fundamental property rights. Specifically, the right of property owners to know when their property is subject to zoning regulation, what is required for them to get a development permit to use their land. Schooldev brought this appeal after the town of Wake Forest denied the site plan and subdivision permits they needed to build a K-12 charter school in the town's jurisdiction. The town denied those permits despite the fact that Schooldev had checked all the boxes necessary to obtain those permits. We are using a visual today. It just shows a basic summary of the parcels. With the Schooldev's plan was to subdivide a 63-acre piece of property in Wake Forest with the charter school going in the middle and the parcel with the dashed line labeled school parcel. This was a case where the politics of charter schools swirled around it, and even though everybody agreed that the relative merits or demerits of charter schools was not relevant to the policy issues at issue in the case, there was testimony about from charter school opponents about opposing charter schools, and the board did discuss their concerns about charter schools during their deliberations. The town says that there was no latent bias in its decision. Rather, the town justifies its denial on claims that Schooldev did not comply with the town's school sidewalk ordinance. That ordinance, which is contained in the town's zoning ordinances, generally provides that schools shall demonstrate pedestrian connections to surrounding neighborhoods. What the town says is that Schooldev did not comply with that ordinance because while it provided a 10-foot wide multi-use path along the frontage of the school parcel, it did not provide sidewalks on the 2 vacant lots on either side of the school parcel. The problem with that argument is that at no point prior to the close of the evidentiary hearing in this quasi-judicial case did anybody from the town tell Schooldev that that was required by the school sidewalk ordinance. In fact, nobody from the town mentioned the school sidewalk ordinance during the evidentiary hearing, and the only party that mentioned that ordinance was Schooldev, and that was to put in evidence of compliance. As a result, the Court of Appeals erred in affirming the town's denial in its 2-to-1 split decision, and this court should find in favor of the appellant and reverse the Court of Appeals for 2 reasons. First, under this court's decision in PHG Asheville, the town lacked the discretion to deny Schooldev's permit applications because Schooldev had presented sufficient evidence to establish a prima facie case of compliance, and there was no competent evidence in opposition. Second, Section 268A22 of the general statutes prohibits the town from denying Schooldev's permits for a lack of sidewalks. The town's denial of Schooldev's site plan and subdivision permits constitute an error of law, and the parties agree, and the Court of Appeals correctly held that it's reviewable de novo. In regards to the first issue regarding the town's lack of discretion to deny Schooldev's permits, the town lacked its discretion to deny those permits because Schooldev met its burden of production and there was no evidence in opposition. This conclusion stems from the 2-step decision-making process that's well established in North Carolina law. That 2-step process first provides that the initial step is that the appellant has a burden of production to establish compliance. And once that applicant meets the initial burden of production, is established a prima facie case, and the town can only deny permits when there is a factual dispute and the record contains competent evidence in opposition. As this court held in PhD Asheville, if there is no evidence in opposition and the applicant has met its burden of production, the town simply lacks the discretion to deny the permits.
On this point, can I ask you what weight we should give to the trial court's finding of fact number 10, where in reviewing this, trial court found as fact the site plan rendering itself did not show pedestrian and bicycle connectivity with surrounding neighborhoods to the west, north, and east. The only pedestrian and bicycle connectivity to Wake Preparatory Academy site was to and from Harris Road and across Harris Road to a neighborhood to the south. Isn't that a finding of fact that we have to accept?
Well, no, because the Superior Court was acting as a appellate court that was reviewing it de novo. And so the Court of Appeals reviewed the Superior Court's decision de novo. This court can review all of the findings of fact de novo because, again, both under the statute, under 160D and under PHG, whether or not Schooldev presented sufficient evidence of compliance with that school sidewalk ordinance is a question of law.
But I understand that whether or not the evidence meets the legal standard is a legal question. But what the evidence shows itself, why isn't that a factual question?
Well, so let me say this. That evidence is correct. And so what the evidence shows is that Schooldev is two things, or a few things. But what the evidence shows is that the area where Schooldev planned to build this school did not have any sidewalks on the road, which is Harris Road. Further, the evidence shows that throughout the process, the town told Schooldev that pursuant to 168-307.1, they believed that Schooldev was exempt from the town's street and sidewalk requirements. Town staff said that in their report that was entered into the record, and during deliberations, the town attorney told the board that, and the board didn't question that. Nobody disputed that during the proceedings. Despite that, Schooldev provided a 10-foot wide sidewalk along the frontage of its campus, and that sidewalk connected to the only two pedestrian connections that were available to any part of this property, which were the two sidewalks to the south. They connected to a subdivision to the south that had a sidewalk that ended at Harris Road, and they connected to about 3 miles of walking trails in a park, a large park that's just south of the property. To the extent that they even were asked to build sidewalks on the two vacant lots, which they were never asked to do, they were never even asked to dedicate the right-of-way for the sidewalks on those vacant lots. It would have been sidewalks to nowhere. The record is clear on that. There's no evidence that they would have connected to anything. And as state law is clear, under 160D-804, which is the relevant statute in terms of what towns can require as part of site plan and subdivision approvals, towns cannot require off-site improvements. In other words, the town cannot require that you connect to neighborhoods if what you need to do in order to connect to those neighborhoods is build off-site sidewalks.
Well, just to follow up, there is a distinction, though, between what the town can require off-site, so outside the subdivision, versus what they could require on-site, correct?
That is correct. But remember that the town, so there's two things going on here. So the town has a subdivision ordinance, and that subdivision ordinance, although the town in this case says sidewalks are not part of the street, that subdivision ordinance, which is in Chapter 6 of their Unified Development Ordinance, says street improvements include everything that's within a street, including sidewalks. The town has never said that this plan was in violation of that requirement, and that's the requirement that would require when you subdivide land to put sidewalks on these two vacant parcels. Instead, what the town has said is that what Schooldev did not comply with was a specific use standard for schools. So what the town has said is there's a specific use standard for schools that requires that you have sidewalks, you provide sidewalks on the site of the school that provide connectivity. And under that ordinance, what the most reasonable interpretation of that ordinance, and that's under the rules of construction for zoning ordinances that this court has laid out for more than 60 years, is that that requires connectivity on the school site, even if you wanted to broaden it, say, on the entire site, to the extent that it can connect to adjacent neighborhoods. It certainly doesn't require, by its very text, that you build sidewalks to nowhere.
So you've explained that there was a connection, a sidewalk that would connect into a large residential neighborhood to the south.
Correct.
I don't think there's really any dispute about that. As Justice Earls pointed out, there's a finding the trial court made about that. So the ordinance says connectivity to surrounding residential areas is required. It seems like that one connection is connectivity to surrounding residential areas. I mean, the ordinance doesn't say connectivity to all surrounding residential areas or connectivity to every surrounding residential area. So it seems like the plain language is satisfied. At best, there would be an ambiguity about how many of the surrounding areas that you have to connect to. And if there's an ambiguity, your client wins because we have to construe any ambiguity in zoning ordinances in favor of the free use of property. Isn't that right?
That is all correct. And, you know, frankly, you just summarized a good chunk of my argument there. You know, and I think what further supports that is, again, the fact that during the evidentiary hearing, which is the only thing the town can base its decision on, nobody said anything about, hey, we actually read this specific ordinance as requiring more than you're giving. Nor did the town say, hey, we want more sidewalks on the 2 vacant lots. Can you provide it? There is no opportunity for rebuttal. And what this court has said is in addition to, you have to construe zoning ordinances strictly in the favor of free use of property, this court has also held that when there is a sort of special understanding, I think the court called it in Humble Oil special facts, and this court revisited that in PHG, those special facts have to be disclosed during the hearing so that the appellant can rebut those special facts or considerations. Now, the town says, well, we were acting as judges, we're going through the proper decision-making procedure, and these weren't special facts, this was just an interpretation of the ordinance. Well, when this court looked at PHG, the court actually found that an interpretation of the ordinance, a determination that the ordinance required more than what was in the specific language of the ordinance, constituted special facts. In that case, it was extra legal requirements of a traffic study that the town said you should have done, or the city said you should have done this, you should have done that. And the court said, that's not in the ordinance, and you didn't give them any reasonable time to respond. And in that case, at least the city council told them during the hearing, this is how we interpret it. One of the things that really undermines, you know, frankly, one of the elements of fair trial that are required to be preserved in these quasi-judicial hearings is that Schooldev never got the opportunity to rebut. The town never said, hey, this is how we interpret it during the evidentiary hearing. In fact, what happened was the evidentiary hearing was held in September of 2020. They then held over, it went to the Planning Commission. A month later, the commissioners come back. So a month later, they come back and they do their public deliberations. And during those public deliberations, what they start talking about first are charter schools. And they talk about their concerns that charter schools don't comply with the town's policy for community-based schools because they're going to bring in students from other towns. They talk about how a charter school at this site might negatively impact the funding of a nearby elementary school. They don't even raise the school sidewalk ordinance until one of the commissioners makes a motion to deny Schooldev's permits on the basis, basically, of those concerns. You know, that motion dies for a lack of second, and then immediately afterwards, without any explanation, there's a motion made to deny the permits on, among other things, a failure to comply with this school sidewalk ordinance, section 3.7.5. The town, when the town finally issued its written decision, it didn't even explain what the ordinance required, didn't make a finding about what the ordinance required, nor did it make a finding as to how Schooldev fell short of that ordinance. That wasn't made clear until this case got to this court, at which point, after the Court of Appeals, frankly, erroneously held that this ordinance could be interpreted to require that you connect to more than one neighborhood, did the town say, well, no, we weren't requiring off-site improvements. We weren't requiring them to show that they connected to all the neighborhoods, regardless of off-site improvements. We're just requiring two sidewalks on the 2 vacant lots.
So
Go ahead. Go ahead.
if we conclude that you made the prima facie showing, do we even need to reach the question of the proper interpretation of 168-307.1?
You do not. You do not, frankly. Schooldev is a developer of charter schools, and they do think that the interpretation of 168-307.1 is important. And so certainly we hope that this court will reach that and reach that in our favor, because as Judge Tyson in his dissent outlined, the plain language of the law does restrict the town from requiring sidewalk improvements. Again,
So on that point, what weight should we give to the fact that there are so many other provisions in 160A, Chapter 160A, that that appear to distinguish between streets and sidewalks, like 160A-296?
the court shouldn't, the court should not give particular weight to that, because a lot of those provisions, again, 160A is a broad chapter, as you know, Justice Allen, I know you spent a lot of time looking at that, but it's a broad chapter of the general statutes that gets into all sorts of levels of municipal power. And the provision in 168-307.1 addresses street improvements. And in doing so, these other provisions distinguish between street and sidewalk in a way that may uncouple them. But in the case of this provision, the ordinary meaning of the word street is undisputed. It generally includes sidewalks. And what the Court of Appeals really found was the reason why was their justification for interpreting 160A-307.1 as not including sidewalks, was they held that, well, there's this exception that says that you can require street improvements if they're attached to the driveway and provide for safe ingress and egress. Well, as Judge Tyson pointed out, that clearly shows the legislature's intent to restrict all forms of street improvements, including sidewalks, because while the Court of Appeals seemed to think that there's no way that sidewalks could be involved in that sort of thing, there's clearly sidewalks that allow students to safely cross the street are an example of what might fit into that exemption crafted into the law. Given both the common and ordinary meaning of the word street to include sidewalk, the context of the statute, the fact that the town in its own ordinances, I mentioned, defines street improvements to include sidewalks, which is, frankly, common across the state. So across the state, you see that what towns do is they will broadly define a street cross-section, and they will say, this is what's required within the street cross-section. In fact, this 168-307.1 cross-references 160D-804, and I know I'm throwing a bunch of statutes around, but that is the provision that says, here's the powers that towns have to basically exact things from developers. And what it says, let me flip to it, is that Towns have the power to do that for the coordination of transportation networks and utilities within proposed subdivisions with existing or planned streets and highways. Nobody contends that, and in fact, as the town of Wake Forest's own ordinances show, nobody contends that in 804 that streets don't include sidewalks. In fact, municipalities across the state commonly use the 804 and that provision that allows it to require streets, to require sidewalks, street trees, all those sort of things. And so in that context, 307.1 was intended to restrict a broad basket of street improvements and not just the roadway between the curb and the gutter, as the town argues.
Can I ask you, so as I understood your argument and your exchange with Justice Dietz, your position is because there's a sidewalk on the south and it creates accessibility to a neighborhood, singular, to the south, that satisfies what the town has enacted through its local ordinances, and there's no dispute that you don't provide connectivity to the neighborhoods to the north and east. Is that right?
That's right. In fact, we couldn't provide connectivity without off-site improvements.
Okay, so with that narrow reading of the statute, of the local ordinances that multiple times talk about connectivity, which I take to be broader than even just access, and the importance of pedestrian access, that schools should be the cornerstone in neighborhoods, I want to see where the boundary of this argument is. So if there were a tract that were 15 acres in a very, with populated neighborhoods all the way around, and the town has said, this is important to us, that we promote pedestrian accessibility, wouldn't your argument say if there were a 1-foot sidewalk that provided say it's like the same picture, but the scale is much larger, wouldn't your argument then really, really undermine what the town has set as its law and its policy about promoting accessibility? Because you'd have a technicality where you had 1 foot of sidewalk at the south, and that would be enough accessibility to satisfy, make your prima facie case?
Well, I mean, again, our argument is that and the town agrees that we only had a burden of presentation. And again, part of, when you're talking about, well, couldn't the town read this broadly to require connectivity? Couldn't they have said this was really, really important? One of the important things here is that the town never said that during the evidentiary hearing. In other words, Schooldev never got the opportunity to rebut or even offer additional sidewalks. And that's important because in this case, you might say, well, why are you here on a site plan and subdivision case? Couldn't you have just revised it, come back 2 days later with sidewalks, and then you would have been done? Well, the problem with that is that when these permits were submitted in 2019, schools were allowed on this property by right. During the approximately year-long process of review of the permits, the town changed its zoning laws and prohibited schools on residentially zoned property like this one. And as a result, the town's decision on this became the whole kit and caboodle. The town, by denying Schooldev these permits and not saying what it might require for connectivity. Again, connectivity is vague, as you point out. It doesn't have a definition and so it has to be narrowly construed under this court's holdings regarding the interpretation of zoning statutes.
Yeah, I don't want to cut too much into your rebuttal time, but just to follow up on that, I mean, taking Justice Riggs' hypothetical, if it turned out there's a situation where a landowner wants to make some kind of improvement to their property and they look and say, wow, I can just satisfy the zoning ordinance by doing a little couple feet of sidewalk on the south end of my property and that'll meet all the criteria. And it kind of feels like a loophole. It's not a loophole because it's your property and the baseline is you can do whatever you want on your property. If the government wants to limit that, it's their obligation to make clear rules. And it seems like what's going on here is there's not very clear rules, and what your client presented as the proposal checks all the boxes of the current ordinances, and that means you made a prima facie case.
That's right. The town was not clear about what it wanted. In fact, it never outlined what it wanted here. Schooldev, despite being told it was exempt under 168-307.1 during the evidentiary hearing from this requirement, still went to the trouble of trying to prove that it met this requirement during the evidentiary hearing. Nobody said anything else. And so, given that case, a landowner has to have the ability to know what boxes it needs to check, particularly to get a site plan and subdivision permit. These are not use permit. These are not a question of should this use be allowed. This is a question of can I build my building on it? And that needs to be a relatively administrative check-the-box process, even if you do it through a quasi-judicial proceeding. And for those reasons, we would ask this court to reverse the Court of Appeals and find in favor of Schooldev and remand this case back with the orders to approve the permits. Thank you.
Thank you, counsel. Hear from the appellee.
Mr. Chief Justice and Associate Justices, may it please the court. My name is Sam Slater, and I'm here today representing the respondent, appellee, Town of Wake Forest. Seated with me is my colleague, Scott Hazelgrove. As we just heard, Schooldev sought to build a school in the town's rural holding district. The town's Unified Development Ordinance required certain infrastructure improvements for the proposal to be approved. And at the hearing and to this day, Schooldev relied upon a novel North Carolina statute to justify its lack of pedestrian and bicycle connectivity. Because Schooldev did not provide the required improvements, the town properly denied the applications and respectfully ask this court to affirm the decision of the Court of Appeals. In today's argument, I'll first explain the statute in question that we've discussed a little bit so far, the evidence submitted at the quasi-judicial hearing, and Schooldev's failure to meet its burden of production necessary to entitle it to the permits. Next, I'll address the numerous and evolving alternative reasons argued by Schooldev to claim that the town wrongfully denied the permits. These include the characterization of UDO 3.7.5, that's the Unified Development Ordinance provision in question, as either a subdivision ordinance or a zoning ordinance, which no matter how it's characterized, was properly authorized by North Carolina law. Second is the UDO's reference to off-premise improvements, which Schooldev has sought to conflate with prior case law barring off-site improvements. And third is Schooldev's latest argument raised for the first time before this court and similar to some of the arguments that Mr. Coleman just made, expressing concerns about claimed due process violations, of which there were none in this case. On the merits first, Your Honors, the town's UDO called for a quasi-judicial hearing, as we heard, that required the applicant to meet 4 findings of fact. These findings of fact, as they're referred to in the UDO, are the same for the subdivision permit and for the site plan permit. They required a finding of consistency with the policies of the town, consistency with all requirements of the UDO, adequate infrastructure to support the plans, and finding 4, no detriment to the surrounding areas. These are pretty common in UDOs for this type of review. The critical section of the UDO 3.7.5 that everybody looked at and has been talking about noted for 2 parts. For schools in the RD zone only, which is where this school was located, that's the rural holding district, the single supplemental requirement for this form of development was noted to encourage walking and bicycle accessibility by school children to schools. It shall be required by the applicant to demonstrate how such accessibility can be achieved given the low density nature of this district. Accommodation may include the construction of off-premise sidewalks, multi-use paths, trails, or greenways to connect to existing networks.
And that was the basis for the denial of the major site plan, but not the subdivision plan. Am I correct about that?
Justice Dietz, it was the basis of the denial for both. 3.7.5A was for one and 3.7.5B for the other, but both under 3.7.5.
Right. Mm-hmm. But it would matter, the A and the B matter, right? So
correct,
provision
yes.
A was for the subdivision, or I'm sorry, B is the subdivision, A is the major site plan. Am I right about that?
I think that's correct. I often flip it myself.
So
yes.
suppose we found that the burden of production hadn't been satisfied on A or B, but not the other. That means that one of the 2 plans was improperly denied, right?
That would be correct on the burden of production analysis. Correct. I mean, that is the standard. I'm going to speak to that in a moment, that where an agreement was applied in the case.
When was the first time that sidewalks were brought up during this process?
The applicant spoke about sidewalks, Chief Justice. The applicant put on evidence, in fact, there was a slide in the PowerPoint presentation to the board that referenced 3.7.5 and indicated the applicant's contention that it satisfied that standard. So I want to highlight that because this is very different from the case law that talks, going back to Humble Oil, that talks about these sort of special knowledge and facts that somebody has that aren't shared. In those cases, and if you've been in a municipal situation, you'll be familiar with this, there'll be a presentation, and again, if it's a little aside, if it's legislative, it's okay, right? If it's quasi-judicial, this is fair trial stuff. You consider the evidence submitted and nothing else. And this is what happened in Humble Oil that's cited for that, no special facts or knowledge standard. A presentation of evidence, and then it comes to deliberation, and the board says, that intersection's been, I know what they said, but that intersection's been terrible for 28 years. They can't put that gas station there. I know what they said, but I know better than them, and they can't do that. And that's very different than what happened here. What happened here was the interpretation of that novel North Carolina statute. And between the time of the presentation on 3.7.5, including the slide to the board as to why they contended it was met, and the deliberation that we talked about, the appellant submitted a point brief. It was a legal brief to the board, and the point brief included the statement, the town cannot require that the applicant provide improvements on or along NCDOT-controlled Harris Road, such as median, sidewalks, and the like. So the effect of 307.1 on the ability to require or not be allowed to require sidewalks, as we've just heard, was a part of the deliberation to start. And
Well, let's talk about the deliberation, not the technical deliberation part, but this whole process. So this was, the plaintiff did not have their first appearance or first interaction with town officials at the quasi-judicial hearing. They had had a process of working with town officials to present a proposal that was compliant, correct?
It is correct with a slight nuance clarification. They had interaction with town staff, who are town officials, correct, Chief Justice, but not with the commissioners. And it would have been improper because of the quasi-judicial nature to do that. It does sort of box the town in because the commissioners are ultimately responsible for making the legal determination here as to what this, I'm sorry.
Well, but the point is, throughout that initial process, no one mentioned that, oh, by the way, you need to do more with your sidewalks and their connectivity. Is that an accurate statement?
It's not, Your Honor, respectfully, because that initial process is not in the record. It's unknown. Those are the sorts of staff meetings and the discussions.
Is there anything in the record that indicates that anybody on the staff at any time said, oh, by the way, you're going to be deficient in what you proposed for any reason?
Not on 3.7.5, Your Honor.
Any reason?
Not that I'm aware of, Your Honor.
So how is that not just totally blindsiding an applicant to have the town employees say throughout the process, what you're doing is okay. You appear at a hearing, there's no evidence to the contrary. Why is that a fair process to then let anyone else, based without any testimony to the contrary, go in and say, oh, by the way, we're going to deny these permits?
My response would be, again, putting yourself in the situation of those pre-meeting discussions with staff. I don't know, and we can't know because we weren't there, but I can nearly assure you that the town staff was not saying, we can't make you do this. I can, in fact, likely surmise the opposite happened, where
But there's nothing in writing. Let's don't surmise. Let's talk about what is in writing. What was that we know was communicated.
The reason that my response to your concerns, which I understand, are that there was a reason that they didn't offer it. And the reason they didn't offer it was their reliance on 307.1. And that was a calculated risk by the applicant in this case. If they needed to check all the boxes of 375, they could offer the connectivity, but they didn't offer it. And
Was there a legal Was there a legal opinion rendered that said, this does not apply?
In the deliberation, and again, I think the deliberation, the record of the deliberation is helpful here. The commissioners wrestled with what was allowed or what's not allowed. One commissioner said, can we really not require sidewalks on their own property? And the town attorney weighed in with some generalized discussion about 307.1 may prevent improvements, including sidewalks. So there was discussion. But again, that legal determination is ultimately the determination of the board. And there's just no way for that board to make that determination prior to the deliberation.
Why did the board not say, we're concerned about sidewalks and connectivity, go back and give us, amend your proposal?
I don't know, Your Honor. I know that although I will say, well, let me answer that a little bit differently. That's kind of along the lines of one of Schooldev's arguments on due process, that they should have just conditioned it, right? They should have said, well, we could approve it, but with conditions. But again, the board was faced with Schooldev's contentions, and this was a legal brief sent to them before the deliberations that said 307.1 says you can't do sidewalks. And it's, so basically that argument is claiming the Schooldev would say, you can't legally require us to do this, but you're violating our due process because you didn't just make us do it anyway. They relied on 307.1 to say, and they did initially, and they are still today, to say that this is not permitted. And so I would speak briefly to 307.1, Your Honor, Chief Justice, because it is so important to the case. I understand.
Before you move on, I wanted to ask you about a comment you made. So you said that Schooldev had taken sort of a calculated risk by focusing so much on the statute, and and you said not enough on sort of the connectivity requirements that are in 3.7.5. But so Schooldev did say we'll build the sidewalk running east to west along the southern side of the development, and that would connect with a large residential neighborhood to the south. You heard my questions for your friend. Well, just based on the plain language of the ordinance, why doesn't that satisfy 375B?
Thank you, Your Honor. The requirement is connectivity to surrounding areas, frankly, plural, as Justice Riggs noted, and
But a neighborhood
might
have many areas. I mean, area is an undefined term in the ordinance, is it not? I mean,
it is in the ordinance, but it's a single connection to a single area. It was called Devon Square. It was apartments that were under development right next to Joyner Park. And you can look at page 6 of our brief as a different image. It's the site plan, and it shows what this school proposal was. It was carving out the parcel in the middle. It was putting the school alone in the middle. It was a multi-use path from driveway entrance to driveway entrance and a stripe to Devon Square. That's it. And so that's what the Superior Court looked at and determined, as Justice Earls noted earlier, there's connectivity to one area, to the south. And again, this goes to
But can you see how, just in ordinary English usage, people were talking and someone said, does this shopping mall or whatever have connectivity to surrounding residential areas? If someone would respond, yes, there's a sidewalk that takes you to that big neighborhood to the south, that would make sense. You'd say, yes, it does have connectivity to surrounding areas. Because if you wanted to know, does it connect to every single surrounding residential area, you would need to be more precise. And I understand your point that you could also be more precise in the other way, and I've said connectivity to a residential area and limited to only one. But the problem is if we're in the middle and there's some ambiguity, your client loses because there's an obligation for you to be clear in drafting the zoning ordinances.
To a degree, Justice Dietz, so zoning ordinances, they can be objective. It's good for zoning ordinances to be objective when they can, right? That's why if you want to build a house, you're 10 feet off the front, 5 off the side, staff can approve it, no issue with that approval. For situations like this that talk about an issue like connectivity to surrounding areas, that's a discretionary standard. That's where the quasi-judicial process comes in to allow an evaluation of that piece of dirt, that particular site, how can this be achieved in this specific context? And the record is pretty clear that there's not a fulsome, that they didn't offer that. There's not, you would expect if they were putting on evidence of connectivity that there'd be a large part of the record that talks about, well, there's this Harris tier back behind here, and there's this neighborhood over here, and here's the existing network. Here's how we tried to do it. We can't make this connection because it's off-site. None of that's in the record. The record is just, you can't make us do this, and so they don't offer it. I want to speak to 3.7.5 because it is important, 307.1 because it is important, and it's the statutory interpretation argument. Statutory interpretation, as this court knows well, begins with examination of the plain words of the statute. Courts must give words their plain and ordinary meaning. And the plain and ordinary meaning of street, as used in 307.1, is not synonymous with sidewalks. Some streets have sidewalks on them, some do not. I know that because I'm trying to get sidewalks on my street currently, and it doesn't have them. Cars drive on streets, people walk on sidewalks. So these words have completely different plain and ordinary meanings, and the court can look only to that statute, 307.1, and make that determination. If the court believes there's some ambiguity, needs to look elsewhere to determine that meaning. A contextual reading of 307.1 shows that street improvements does not include sidewalk improvements. This is the exercise that the Court of Appeals engaged in, the statutory interpretation canon, Noster Associates. What do the words around it mean or imply? So street improvements, and again, this is, just to kind of reorient, typically towns can require street improvements in connection with different forms of development, multifamily. 307.1 limits that, and they limit it in two ways. It's to, has to be limited to physically, the improvements have to be physically connected to the school's driveway, limited to safe ingress and egress. That's the statutory language. And so the Court of Appeals correctly held that the legislature could not have intended for sidewalks to be required only for safe ingress and egress to the street system, and all sidewalks around a school site that a town could require must be physically connected to the school's driveway. Again, that's consistent with looking throughout the rest of 160A, like we've already discussed briefly. For example, 160A22 a city shall have no power to levy special assessments for street or sidewalk improvements in certain circumstances. I also want to speak briefly about the cross-reference in 307.1. There's a cross-reference to the statute that empowers the DOT to do certain things. The cross-reference is to 136-18 paren 29. Schooldev has argued throughout the case that that's probably a mistake, and the reference really should have been to 29A. One, the statute's been amended 4 times. That's never been changed. And 29 is what gives the DOT power, it talks about what the DOT can do around driveway improvements, turn lanes, medians, about connecting sites into DOT roads. So that's entirely consistent with this limitation on municipal power being only about street improvements and not about sidewalk improvements.
So what about, how do you deal with this court's traditional treatment of sidewalks as being part of streets in cases involving city liability for torts?
That's addressed just by the statutories of canon, the canons of statutory interpretation that we've just discussed. So while relevant, you cannot consider that just in the plain and ordinary meaning of the words in the statute 307.1. And then the other provisions that I've just cited, again, we've argued several ways. It's unambiguous, and if it's not unambiguous, then you apply that Noster Associates to see that this can't possibly lead to this result.
But don't we assume that the legislature, when it passes a law, is aware of relevant decisions from this court and other statutory provisions?
I think it's a fair assumption.
So don't then we have to assume that the legislature is aware of all that case law out there in which this court has used the word street to include sidewalks?
It's something that can be considered, certainly, Your Honor, but it must be considered along with everything else that says exactly the opposite. That street and sidewalk are used differently. 160A references that we've looked at are that way. There is no, it's only controlling if you believe it's unambiguous, which we contend it is. A street is a street, it's not a sidewalk. If it is ambiguous, then the court can consider these other things in informing the meaning of that term.
I just want to make sure I understand clearly. Did the town deny these 2 applications for the failure to show pedestrian access and connectivity within the subdivision, or because they also didn't have a plan to create sidewalks outside the subdivision?
The written decisions just reference the failure to satisfy the requirements of 3.7.5, and that goes to the burden of production that I'll discuss next. But there's no indication that there was ever a requirement or an exaction to say, you know, you're missing sidewalks over here by the shopping center, or you're missing sidewalks down here. So I would contend there's nothing in the record to indicate that the town ever based the decision on outside the subdivision improvements or lack thereof. But I don't want to mischaracterize the words in the written decision, which just rely on 3.7.
So let me ask you that, because now we're talking about 3.7.5A, which is the basis of the denial of the major site plan. And the language there, I have a similar ambiguity problem with that language, but I'm wondering if it can be corrected. So, you know, as your friend argues in the briefing, if this is requiring a property owner to make off-premises, to show that they can make off-premises changes like trails and sidewalks and things on other people's properties, that would be a major problem. You know, the government can't do that. I don't think you're suggesting otherwise. But wouldn't the way to square this, to know that that's not what this ordinance means, be to look at the passive voice in kind of the operative language here, which is where it says, you know, the applicant to demonstrate how such accessibility can be achieved. It's in the passive voice. But wouldn't that be because, so here, for example, the applicant's showing, well, we'll put a sidewalk from east to west on the south side of the property we're going to develop a school. And then we can achieve, you know, the accessibility can be achieved because you're the government, you have the power of eminent domain. So if at some point in the future, you want to connect all this to some other properties that are developing and run across the rest of the subdivision and the other properties that surround them, you can condemn the property and build a sidewalk. So, and couldn't we fit that all together and then say, well, they met the burden of production because they've shown they're going to build the sidewalk on the south side of the property?
Justice Dietz, the sidewalk connectivity is, as you note in the language, it's like we talked about before, it can't be precisely defined. And so you look at it uniquely at this site. And to the off-premise, off-site distinction that we're discussing, that language is, and I'll speak to the Court of Appeals decision, that language is a quote in the Court of Appeals from that 3.7.5A provision that says that the connectivity may be achieved by doing these things. It's not a prescription. I am, of course, I agree with you completely. The town can't require and didn't require off-site, outside the subdivision improvements. You know, oh yeah, you can get connection, but you got to get an easement from your neighbor, Steve. It's not, you can't do that. You can't condition the site on that. But it didn't do that here. And to the extent that there's concern as raised in the competing petitions for discretionary review on that issue, off-site versus off-premise, this court could address that and pretty cleanly, I think, articulate that off-premise as used in the language of the ordinance is not a contention that all developers, or all municipalities rather, are now permitted to require off-site improvements contrary to the case law, as you mentioned.
But my question is, so, and I think this is getting to the point that Justice Earls was making, is there any dispute that if you extended the sidewalk along the southern side of the other two portions of the subdivision, that it wouldn't connect into anything?
Again, I want to answer this in a couple ways. We should be able to look at the record. This discussion should have happened on the record, and it didn't happen because they didn't offer it and they relied on the statute to not offer it. But knowing that site, if you connect across that southwest parcel, there's connectivity back there. There's a roadway. There's a commercial area back there. I mean, I don't know now that, and I can't point to the record.
Couldn't Schooldev say, so we're going to build this sidewalk here on this piece of property, and then just looking at the plain language of 3.7.5A, we're demonstrating that the accessibility can be achieved, because in the future, if there's a need to have sidewalks because you want to have connectivity to something else further down on either end of the southern side of this subdivision, that you can use eminent domain and build the sidewalk there.
The standard on 375 is applied to the application at the time it comes in. I mean, I think going to the step
But that's why I'm struggling with the can be achieved, because It doesn't say,
Well,
it's sort of like an aspirational language, like,
Sure.
in the future, if it needs to be sort of thing.
I think, I think what I'd respond to that is, if it's a hypothetical, Justice Dietz, if a small island were zoned for a school and it's surrounded by water, connectivity can't be achieved there. But they've already determined a school can be there, so that wouldn't, in that case, wouldn't be a proper basis for denial. It's just, it's the merits of the site. It's the nuances of that particular site, the transportation network around it, how it can be achieved or not, right? And put on evidence of achievement or inability to achieve and why. And what the town contends is that just lacked here because of this reliance on the statute to say, whether they did it in the staff meetings, Chief Justice, or where, there came this line that, well, 307.1 says sidewalks are out. So we're going to offer you this on the road frontage. This is all we're going to do, and we're going to connect you to Devon Square. But there's no ability to require more than that. I do want to speak before we run out of time on the burden of production, because this is important as well. The burden of production, as referenced in PHG, requires the applicant to put on competent material, substantial evidence, tending to establish the existence of facts and circumstances that would entitle them to the permit that's sought. So there's certainly a standard there. I think, frankly, it comes from substantial, right? The requirement that the evidence be substantial. The hypothetical I've thought of in the past is similar to what Justice Riggs raised. Look at this site. It's a school site. The applicant could stand up. There could be no sidewalks anywhere, and in the backfield, a 6-foot by 2-foot concrete block. And the testimony, truthful testimony, would be, as you can see, we're offering sidewalks on the site, so we achieve the requirement. And nobody opposes it. Nobody comes in. There's no contrary evidence. Certainly, the board still has the ability to say, that doesn't do it. It's still a legal issue. It's the burden of production. We agree with that. But if it's lacking, the board still has the ability to determine that it's lacking without contrary evidence coming in and arguing that it's lacking.
I want to understand your response to what I understand the appellant's argument to be, that they couldn't provide pedestrian or other access or connectivity to any of the other neighborhoods without also building sidewalks outside the subdivision.
Justice Searles, it's a good question. I don't understand that particularly myself, again, because the record doesn't reflect that form of discussion at the hearing. There was not a discussion about the surrounding neighborhoods to the west, north, and east, and whether it could be achieved or couldn't be achieved, whether extending the multi-use path to get to that road where you see the roundabouts would have done more to meet that need. And again, the need we're talking about, it's in 3.7.5A.
Yeah, but I think the answer to Justice Earle's question is wrapped up in the hypothetical that you were just describing, because I'm not sure I agree with you about the state of the law. So if you built that tiny little concrete connector, and that satisfied the plain language of the ordinance, and they presented to the government an application that said, we did it, we built this little connector, then without counter evidence, I think the state of the law is going to be required to grant it. And the point is, if you don't want that kind of a loophole, write a better ordinance. And so here, they didn't have to show connectivity to any other residential areas, because they said in the application, we're connecting this neighborhood to the south, and that satisfies the plain language of 3.7.5B.
Well, I would respectfully disagree with how you've just characterized it, and say that the burden of production still requires that the applicant put on competent material, substantial evidence tending to study. They still have the burden. It's different than burden of persuasion, admittedly. It's different. But it is still the applicant's burden. And the ordinance in this case, 3.7.5, that is the one thing, the one thing the town raised their hand and said, if you're going to put a school in the rural holding district, this is what it needs to do. It needs to achieve the connectivity to the surrounding areas, because it's in a place with steep slopes or in a rural part of town. We want school children walking. And again, this goes to the hypothetical of 3.7.5, excuse me, of 307.1. That is a very that is a very justified need. It goes back to statutory interpretation 307.1. To think that the legislature would have done that would lead to observed results. If you have children and you've taken them to school, or you have neighbors with children that go to school, you know the importance of getting them there every day safely. And to think that 307.1 was written to tell every single city and town in the state of North Carolina that you can't tell a new school to put sidewalks anywhere unless it's physically connected to the school's driveway and required for safe ingress and egress. That's an absurd reading of that statute, and it ties back to the policy behind 3.7.5 that wants to encourage that form of pedestrian and bicycle connectivity, to not create schools that are auto only, and create that walkability and accessibility. And so
Some of the, oh, sorry.
Are you essentially saying that that 3.7.5 isn't more absolute because in some instances it would simply be impracticable to require connectivity, and that part of the burden of production is to show why, where there isn't connectivity in a plan, it's impracticable to provide it?
I would agree, Justice Allen, that the requirement is that the applicant demonstrate how it can be achieved, and it might be done in these various ways. So for those reasons, Your Honor, I respectfully ask that the court affirm the decision of the Court of Appeals. Thank you.
Thank you, counsel. Rebuttal.
Excuse me while I button my coat. I want to talk very briefly first about the question of 3.7.5, because as the town said, I believe they said, the requirements can't be precisely defined, so you have to look at it on a case-by-case basis. That is exactly what the court has said for decades cannot be done in a quasi-judicial proceeding. For instance, in application of Ellis from 1970, this court held that that a board cannot deny permits in their, quote, unguided discretion, or stated differently, refuse it solely because, in their view, in this case it was a mobile home park, would adversely affect the public interest. The commissioners must also proceed under standards, rules, and regulations uniformly applicable to all who apply for permits. In this case, that's what's required. And as I outlined, the only way to uniformly apply this ordinance is to read it in conformance with the rules of construction for zoning ordinances, and to read it as allowing maximum use of the free use of property. It requires some connectivity, but I'll note in 3.7.5a, in that last sentence, what it requires, it says accommodation may include, sidewalks, multi-use paths, or greenways to connect to existing networks. So in other words, they don't have to build sidewalks anywhere. That's clear under the ordinance. What they have to do is build connections to existing networks. And what the record shows, however you want to debate it, what the record shows is that the only two networks that my client identified were the two networks they connected to. There is no dispute about that. There were no other pedestrian networks identified. As Justice Newby said, this was, frankly, a blind side by my client. My client, as the town has conceded, there was no evidence in opposition to this case. The town did not, there's nothing in the record that indicated that the town would require additional sidewalks beyond what Schooldev provided. In fact, Schooldev was told that they were exempt. It wasn't just that Schooldev was taking a calculated risk and hanging their hat on that. The town, in their staff report, said 307.1 exempts Schooldev from these requirements. And further, as the town has acknowledged, during the commissioners' deliberations, commissioners asked the town attorney, hey, is this right? Does 307.1 prohibit us from requiring sidewalks? And the town attorney said, yes, generally speaking, that is correct. And there was no debate about that. In fact, as the town has acknowledged, they didn't raise 307.1 in the evidentiary hearing. They didn't say that it didn't apply during their deliberations. They didn't even say it didn't apply in their written order. The town didn't raise it until they got to the appeals of this case. So, the town, if it had wanted sidewalks, it should have told Schooldev that it wanted the sidewalks. And under the law, it could have asked for them, or as we've noted in our brief, the town has the ability to condition approval on the provision of sidewalks. Town could have easily done that here, and it didn't. Under North Carolina law, the school dev has checked all the boxes required. It was the only party to present any evidence that it complied with the school sidewalk ordinance. Nobody from the town disputed that. And school dev couldn't have anticipated the requirements that the town now claims are at issue. Accordingly, the Court of Appeals decision should be reversed, and the case should be remanded with an order requiring the town to approve school dev's permits. Thank you.
Thank you, council. Thank you, everyone.